Mr. Baldry, there are perhaps two matters I might mention before you begin your submissions. The first is that when we granted permission to appeal, we allocated 3 days for this hearing. Having now read the parties' written cases and the judgments below, well, I wouldn't underestimate the difficulty of this. It's not as complex as we thought, and we're hopeful that we may get through the case in less than 3 days. The other point I thought I might mention is, I'd say so realizing, of course, that you're all very experienced advocates. We are anxious that you allow yourself enough time to cover the issue of remedy fully. Obviously, we want to hear you on all aspects of the case, but that strikes us as perhaps a particularly tricky aspect of this case. So,
thank you for that indication, and we'll try and resist the temptation to fill up the time with submissions. I'm optimistic that we will be able to do that. I appear for the revenue with Mr. Connolly. The respondent trustee is represented by Mr. Gammy and Mr. Rivet. This is the latest case to come before this court concerning the compatibility of European law with domestic provisions. It concerns a claim made by one of two groups of pension funds. The first group of cases, which was headed by the trustees of the BT pension scheme, followed on from the decision of the Court of Justice in the franked investment income case. Pension funds such as BT, the BT pension fund, were one of the main shareholders in the BAT groups of companies, and so were sort of indirectly affected by the decision in that case. And those pension funds brought statutory claims for the repayment of tax credits related to sort of economic double taxation during the period where UK companies paying dividends pay dividends to pension schemes which were entitled to reclaim the tax credit. And so those pension funds brought statutory claims for the repayment of tax credits on their actual dividends, both UK dividends, called foreign income dividends, and overseas dividends. Some of those claims have been resolved under the statutory appeals process, of which my Lord Briggs was involved in. Others have been essentially stayed pending the outcome of your Lordship's decisions in cases such as FII and Prudential, as to work out what the nature of those claims were, and will now resume as sort of High Court restitution damages claims in the near future. So that's one group of claims by pension funds, and the second group of claims are those in respect of the manufactured dividends received by pension funds in the course of their stock lending activities, and the present case is serving as an informal test case for these claims. And the main issues are, as whether the Tribunal and the Court of Appeal have held, the domestic rules are incompatible with Article 63 of the Treaty on the Functioning of the EU, and whether the trustee should be entitled to a statutory repayment of certain amounts of tax withheld in respect of those manufactured overseas dividends, or MODs, as they're called. Unlike the decisions in FII and Prudential, this case has travelled up the domestic courts without being referred to Europe. No issues have been referred, although the courts below have sort of differed in their approach on the various aspects. And there is much common ground on the European law principles to be applied, not without their difficulty, but what really has divided the parties and the present appeal is the true effect of the domestic rules on manufactured overseas dividends, and what remedies are available under national law if there is any incompatibility. So the revenues submissions come in 4 parts. The first concerns restriction, whether the domestic regime did give rise to any restriction on the free movement of capital, and the revenues case is that it does not. The second part concerns justification, and the third part is on the footing that the Court of Appeal were right to hold that the relevant withholding tax charge was incompatible with EU law, and that engages the remedies issues. There is a fourth part concerning a new point that the revenue have raised concerning the standstill provision under Article 64. The revenue have sought permission to raise that. It may be convenient if I raise that issue after I've dealt with restriction, because that seems to be most naturally linked to that issue. In terms of timing, we will take your Lordship's comments on board and possibly depart from the timetable, and I'll try and make as much headway as we can today. So on restriction, the question here is whether the UK provisions did restrict the free movement of capital, and on this issue, the trustee has argued its case throughout these proceedings in the same basis, and that case was accepted by the upper tribunal, but was rejected, we say, by the Court of Appeal, which nevertheless found favour with the trustee on the restriction issue on a different basis, which we've referred to as the impairment basis. And I propose first to deal with the trustee's pleaded case, and then turn to the Court of Appeal's sort of impairment analysis. And the trustee's case on restriction has 2 essential elements. The first is that the domestic regime treated the trustees' mods paid in respect of their overseas shares differently to the manufactured dividends paid in respect of their UK shares. And they've been referred to below simply as manufactured dividends, or MDs. And that's the first element. The second element of the trustees' case is that difference in treatment was liable to dissuade a pension fund from investing in overseas shares. And we say the trustee is wrong on both counts. The alleged difference in treatment is identified in the trustee's written case at paragraph 39 and repeated elsewhere. And this case is that the trustee has suffered a UK tax charge in respect of mods from overseas shares, but did not suffer any UK tax in respect of manufactured dividends from UK shares. So at paragraph 84 of its written case, the trustee asserts that it's difficult to conceive of a more straightforward example of precisely the type of discrimination that is offensive to the rights protected by Article 63. So the trustee's case is on its own account a very simple one. It's that the trustee is liable to tax on a mod, and therefore it's suffered tax on its manufactured overseas dividends, where it's exempt from tax and has not suffered tax on its manufactured dividends. And HMRC's response to that is equally simple. It is that there is no difference in treatment of mods, and the tax treatment of mods and manufactured dividends in the hands of the trustee was the same. They're exempt from tax. And as this is such an important point, I'd like to go into it in a little bit more detail, just to identify precisely what manufactured dividends and manufactured overseas dividends are, because that will inform what the trustee's income was. So can I take you to the definition of manufactured dividends and mods, and then we'll look at the statutory provisions which exempt them. So in order to identify a manufactured dividend and a mod, you looked at the the statutory definitions. That's found for manufactured dividends in paragraph 2.1 of Schedule 23A of the Income and Corporation Taxes Act 1988. That's Authorities Volume 1, Tab 1, electronic page 857.
If it helps you, I should say that we have paper copies only of the parties' written cases and the judgments below.
And your lordship.
Some of us have.
Oh, well, yes.
Is it sufficient if I refer to the electronic?
Yes, yes, please.
Number? Yes. So electronic page 857. And this is just looking at what a manufactured dividend is. Paragraph 2 at the bottom of the page says that this paragraph applies in any case where, under a contract or other arrangements for the transfer of UK equities, one of the parties, a dividend manufacturer, is required to pay to the other, the recipient, an amount, a manufactured dividend, which is representative of a dividend on the equities. The definition of manufactured dividend refers back to the contract. It's the amount that is required to be paid under the contract. And the definition of a MOD, manufactured overseas dividend, is found under paragraph 4.1 at page 862. Paragraph 4.1 says that the paragraph applies in any case where, again, under a contract or other arrangements for the transfer of overseas securities, one of the parties, the overseas dividend manufacturer, is required to pay to the other, the recipient, an amount representative of an overseas dividend on the overseas securities. And in this schedule, the manufactured overseas dividend means any payment which the overseas dividend manufacturer makes in discharge of that requirement. So both the manufactured dividend and the MOD are defined by reference to the underlying contractual payment which the borrower makes to the stock lender. The essential characteristics of the stock lending transaction have been set out below, so I don't need to go into those in any detail. A manufactured dividend, whether it's paid in respect of a overseas share or a domestic share, is a contractual payment made by the borrower to compensate the lender for the dividend that they would have received had they not lent the share. And we say that the payment which the overseas dividend manufacturer makes in discharge of that contractual payment is simply that. It's the final amount that the borrower is obliged to pay. So if, as here, the lending agreements provided some sort of computational mechanism to arrive at the amount to be actually paid, the only payment which is relevant in identifying the MOD, or the manufactured dividend, is the final payment which is made in discharge of the contractual requirement. It's not an intermediary amount stated in the computation of the final amount to be paid. So that's a MOD and that's a manufactured dividend. The next question is, are they taxed differently in the hands of the pension fund, such as the trustee, from manufactured dividends? And we say they're not. Both manufactured overseas dividends and manufactured dividends, the payments are exempt in the hands of the trustee. Manufactured dividends are deemed to be dividends by virtue of paragraph 2.2 of Schedule 23A, and as such are exempt in the hands of the pension scheme as investment income derived from the pension scheme's investments, which is exempt under section 592 2 of ICTA, and that is, for your reference, page 832. The manufactured dividend payment itself, in that case, is deemed to be a dividend and is treated as the relevant receipt for income tax purposes. With regard to manufactured overseas dividends, exemption from income tax for pension schemes was specifically provided under Regulation 3.1 of the Manufactured Payments and Transfer of Securities Tax Relief Regulations, 1995. And that's electronic page 882.
So just going back for a moment to the point you made a moment ago, that the mod is the amount paid, not some intermediate amount used for the purposes of a calculation. The implication, I think the implication is that the mod, as defined in the tax legislation, is the net amount, whereas the manufactured dividend defined in the standard form of contract is the gross amount. Is that right?
In both cases, it's the payment which is made.
Well, I'm looking. I was looking at the clause. Let's see. I was looking at the clause on page electronic 268, which is in the Court of Appeal judgment, paragraph 3. This is simply the clause that they quoted.
Is it the clause from the stock lending agreement?
Yes, the Osler.
Yes.
And it says, subject to subparagraph 3, the amount, the manufactured dividend payable by the borrower shall be the amount of the relevant income together with an amount equivalent to any deduction, withholding, etc., on account of tax made by the relevant issuer.
Yes.
So it looks as though that's the gross amount.
Yes, this is an overseas stock lending agreement, so this is only concerned with sort of overseas shares.
Yep.
So, yes, one starts with I think the 4B1 referred to above imposes a general obligation to pay. 4B2 starts with the computational subject to subparagraph 3.
Yep.
Then the amount payable is the gross amount. Yep. We agree. And then, but in the present case, all the transactions would have fell within subparagraph 3.
Yes. Because
the borrower and the lender were UK resident in the UK.
Yes. So under 3, the borrower has to pay the manufactured dividend, which is the gross amount, less amounts equal to the tax payable to the inland revenue.
Yes, and so, but the effect of paragraph 3 is it's the net amount which is paid, and therefore it's the net amount which is in discharge of that requirement. The net amount is paid, and that is the mod.
Yes, we just have to be a bit careful about the language, because the definition of the manufactured dividend in the contract is the gross amount, whereas in the tax legislation it's the net amount.
Yes, yes. One sees that the Osler sort of tracked generally the exact form of the manufactured overseas dividend, but they didn't need to call it a manufactured overseas dividend in this contract. They simply called it a manufactured dividend. But the fact was, it was the net amount that was paid.
Yes, and the lender, the borrower has a contractual obligation to account to the Inland Revenue for the relevant tax. But of course, it may not necessarily pay that tax because it may be able to set off that liability, I suppose.
Yes, I think accounting here means putting it in the accounts. It goes into the account. So whether it's actually physically pays any money at all, which we don't know ever happened, it would have been required to account for the relevant withholding tax on its returns every period.
And if it's able to set off the liability against its own tax liabilities, I'm sorry, it's against its own, for example, tax credits or losses, or whatever, then presumably it's regarded as the tax liability of the borrower.
Well, there were bear in mind, there were two ways of setting off that functioned under the regime. There was the sort of automatic set-off where the dividends were matched. So if you had a simple case of the ORCI simply receiving a dividend and paying it on, or indirectly receiving a dividend and paying it on, then the ORCI would simply net one off against the other. There were other occasions where the dividends could not be matched because the ORCI might have sold the share, and in that case, the ORCI had a different form of set-off under Regulation 9, right, where it didn't actually just, the dividend didn't travel up the chain. The right. ORCI had this liability to account, but in that case, it could choose to offset any of the other various creditable amounts which it had.
You're going to be taking us to this, are you?
Yes.
Yes. It's important we're clear as to who is actually liable for this tax.
Yes. Yeah. Exactly. But so that's right. That deals with the contractual position. I was going to take you to the provisions which exempt the mods in the hands of the pension fund, and that is page 842. So 882. These are regulations made under inter alia section 737D, and in the regulations, manufactured payment has the meaning given by section 737D2, and that included manufactured interest or manufactured overseas dividend. And so any manufactured payment, including a manufactured overseas dividend made to a person for the benefit of a scheme referred to in section 592, shall be treated as comprised in income of that person that is eligible for relief from tax by virtue of that section. That's regulation 3. So the manufactured overseas dividend is treated by that as comprised in income that's eligible for relief. So the effect is that the contractual payment, which we've seen, which is the manufactured overseas dividend, is exempt on that basis. So the sort of simple proposition on which the trustees' case is based, that their mods suffered tax, whereas their manufactured dividends did not, is not right, simply as a matter of the black letter law. There is no difference in treatment between the mods and the manufactured dividends received by the trustees. The mod which represented the overseas dividend the trustee would have received was exempt from tax, and the manufactured dividend which represented the UK dividend the trustee would have received was exempt from tax. So it's not the case that mods suffered tax while the manufactured dividends did not suffer tax. Both streams of income, once you've identified them, were exempt from tax in the hands of the pension scheme.
But they're just different types of stream.
Yes.
One's a net. Back to the source. There was a gross stream.
Yes. But the trustee's response to that is, but there's this prior stage of taxation which has taken place. And the trustee says that the contractual mod that it receives represents what is left of its income after tax has been taken out of that payment by the borrower on behalf of the revenue. And the trustee's case is full of assertions that the mod is taxed in the hands of the pension fund. But in a nutshell, the trustee's case is that the revenue through the borrower takes tax out of the trustee's mod income under paragraph 4.2, but then is refusing to hand it back to the pension scheme in reliance of the terms of paragraph 4.4, which is the paragraph that treats the amount that has been deducted as an amount of overseas tax. And at paragraph 56 of the written case, the trustee states that the effect of paragraph 4.2, this is quoting from 56 at page 133, the trustee says that the effect of paragraph 4.2 in the circumstances in which each of the claims arose was to impose an obligation on the ORCI to deduct the mod withholding tax on each mod it paid to the trustee. But the paragraph 4.2 charge doesn't operate by reference to the actual contractual mod which is payable by the borrower. It operates by reference to a notional amount, namely the gross amount of the mod, as we've set out at paragraphs 24 to 26 of our written case. And we say that the trustee's case always depends on their conflating the contractual mod and the gross amount of the mod. If I can take you to paragraph 4 of Schedule 23A, which contains the mechanism by which the deduction takes place. You'll have seen the terms of this cited in the decisions below. The legislation as it stood in 2004-2005 is set out in tab 1 of Authorities, volume 1, that's electronic page 862. We've seen exactly what the mod is. We then need to consider what the gross amount of the mod is, because the core obligation under paragraph 4.2 is that where the paragraph applies, i.e. where the mod has been paid, the gross amount of the mod is treated for all purposes of the Tax Acts as an annual payment, and that takes you within the deduction at source mechanism. And the gross amount of the manufactured overseas dividend is defined in subparagraph 5 little b over on page 863. And under subparagraph 4.5b of Schedule 23A, the gross amount of a manufactured overseas dividend is an amount equal to the gross amount of that overseas dividend of which the manufactured overseas dividend is representative. So the gross amount of the overseas dividend is then defined by subparagraph 5c as an amount equal to the aggregate of those three elements stated in little 3, that first, so much of the overseas dividend as remains after the deduction of the overseas tax, if any chargeable on it. 2, that the amount of the overseas tax, if any, so deducted. And 3, the amount of the overseas tax credit, if any, in respect of the overseas dividend. So 1 and 2 are clear. 3 is a little further explanation, because that overseas tax credit would be a reference to the tax credit in respect of economic double taxation, which might be granted under the terms of the UK's double tax treaties. It's not relevant to pension funds. A number of treaties provided that the state in which the company was resident would grant a UK resident shareholder who received a tax credit a tax credit equal to, say, half of the tax credit which the shareholder who was resident in that state would have got, as a means for relieving double taxation. So the UK taxable shareholder who received a dividend would get the dividend plus a tax credit which it could use to go and claim a repayment of the underlying tax suffered in Italy or wherever. So the gross amount contains this additional, which is not relevant for our case, because a pension fund would never be entitled to any amount of the overseas tax credit. But where this becomes relevant is that one's just looking at the concept of what the gross amount of the manufactured overseas dividend is, and it's an amount equal to the gross amount of the overseas dividend, of which the manufactured overseas dividend is representative. There's some confusion in the courts below as of what that meant, whether looking at some foreign dividend that was paid to some completely separate person that we didn't know about. But we say that's not correct. The focus here is on the manufactured overseas dividend is looking at the thing that is representative of. So it's the overseas dividend of which the manufactured overseas dividend is representative of, which is the dividend which the lender would have got. That's the nature of the compensation payment under the stock lending agreement, is to give a payment of the dividend that the lender would have got. So that's the dividend which really is the dividend of which the mod is representative. And it's looking essentially at the dividend that would have come to the UK. And that's, you can tell what that would be by looking at the treaty and saying, well, yes, I would have got, would have suffered withholding tax of this amount within 2, and I would have got a tax credit, whatever the treaty says. But it's not looking at some totally hypothetical dividend if the share had been sold and it's paid off to somebody else. But that's looking at the term of what the gross amount. But on any view, it's a grossed up figure which contains those extra elements, and that was something which the trustee would not have received, have it received the actual dividend, and it's something that the gross amount is not something that the trustee received under the contracts. In both cases, the trustee gets the net amount. And it's it follows that the definition of the gross amount is the financial construct which is treated as the annual payment, and it's that amount is the same as the gross amount of the dividend that the lender would have received. And the effect of paragraph 4.2 then, this is the provision which the trustee seeks to characterise as the provision which imposed the tax charge which reduced the trustee's income. And we say that's incorrect. Paragraph 4.2 does not impose a tax on the trustee's income. It imposes a an independent tax charge on the dividend manufacturer in respect of this notional amount, the gross amount of the mod. And as we've set out in our written case, the important point to take from paragraph 4.2 is that it contains these two deemings. The first is the grossing up of the mod, and the second is that it is that grossed up amount which is deemed to be the annual payment, and the obligation to deduct under paragraph 4.2 is an obligation to deduct tax at the rate of relevant withholding tax under section 349, which is simply the machinery for collecting tax at source that applied to annual payments, and that's applied to the grossed up mod. And as the upper tribunal recognised at paragraph 30 of its decision, there's no statutory deduction as such from the amount actually paid by the borrower to the lender. So the upper tribunal understood that although paragraph 4.2 adopts the machinery of deduction at source, it operates in a way which is very different to the ordinary situation where section 349 requires a deduction of tax out of a taxpayer's income. And there are two main points of distinction. First is simply the quantum. In an ordinary situation where section 349 of the Income Taxes Act applied to require a payer to deduct tax from a payment, it was a payment to which the payee was entitled to. So in an annual payment of, say, under a covenant or whatever, one person would be obliged to make a payment of 1,000, and then the payer would deduct tax at the basic rate and pay that over to the revenue, and it would be taking that tax out of the sum that's otherwise due. And in that ordinary case, there's no dispute that the tax paid by the payor, and which has been deducted out of the sum that's due to the recipient, is treated as a payment of income tax made on behalf of the recipient, and thereby discharging the recipient's liability. That's not expressly stated under this rule, but it simply follows from the operation of the Taxes Act. But in that situation is one in which the recipient has the pre-existing entitlement to the 1,000. That's the income of the recipient, and the 200, whatever, is deducted from that income by the payor. By contrast, as we've seen, that the trustee was contractually entitled to a payment of the net amount, the 85. That was the amount payable to compensate the trustee for the dividend it would have received. So the relevant withholding tax charge under paragraph 4.2 is this charge on a notional amount, the grossed up amount of the mod. It's not a charge on an amount which the trustee would, absent 4.2, receive or be entitled to. So it's of a completely different character to the ordinary application of section 349 to annual payments. So that was just looking at the quantum to which the withholding applies. And the second main distinction between the scheme of paragraph 4.2 and the treatment of actual annual payments is that in the ordinary case, there would be a distinct tax charge somewhere in the Acts on the annual payment, which brings them into charge to tax. We've listed them in paragraph 27 of our written case. I think, as the trustee points out, the reference to section 63 should actually be to 64. But just making the point that income always needs to be charged to tax somewhere in the Act, and an annual payment would be charged under the provisions which charge annual payment. So that's why the 1,000 annual payment that's due to the recipient is chargeable to tax, and they are the charging provisions, whereas what a deduction at source provision, such as section 349, is essentially a collection mechanism. It renders the payor of the payments liable for deduction, liable to tax on the amount deducted. And under subparagraph 4.2, looking at it in isolation, the charge is on the dividend manufacturer. That's the only entity which becomes liable to account to the revenue for the relevant withholding tax charge, and the entity which the revenue can assess for that. The obligation on the part of the dividend manufacturer to account for the tax to HMRC arises 30 days after the chargeable period, and that's all within Regulation 11 of the MOD's regulations. And I will come back to these to go through the offsetting provisions in more detail, but just looking at the position of who accounts for the tax that's deducted, well, it's the dividend manufacturer using the procedure under Regulation 11 on page 877.
So forgive me, just thinking aloud for a moment. The amount of tax deductible doesn't depend on the terms of a contract between the lender and the borrower.
No.
Or the amount payable under that contract. It depends simply on the amount of the dividend which would be payable on the overseas shares which have been lent.
Yes.
And the withholding tax that would have been payable on those shares on certain assumptions. Right.
Yes. We've seen it in the present case. The contract happened to sort of track the legislation, but it didn't need to. It wouldn't make any difference to the tax consequences of the payment.
Yes.
But paragraph 4.1 contemplates a stock lending agreement under which there is a contractual entitlement to the gross, and then says, but for our purposes, we're going to treat the manufactured overseas dividend as the net amount after the deduction, the annual payment type deduction, which is then provided.
I think that
it's not inherent in 4.1 that the underlying stock lending contract only creates a contractual entitlement to the net.
Maybe not, but it's focusing on the payment that's made.
Exactly, that's my point. Yes. What it says is what we're here focusing on is what he actually pays, but that must be after his obligation to deduct, which is then provided for.
They may assume that, yes.
So, insofar as there may be an appearance of tax being suffered, to put it in a neutral way, by the lender of the shares, is that simply an appearance created by the parties' contract?
Partly by the parties' contract, but that can't matter for the question that we're looking at. I mean, I think my learned friend would say it doesn't matter what the contract said, as a matter of law, the effect of these provisions is that tax is being taken from this gross amount. But we say that can't be right. There has to be a sort of contractual right to the gross amount which is being taken away from the trustee in order for the trustee to complain he's suffered tax so that he can reclaim it from the revenue. And a repayment claim arises because the trustees had some of its income diverted to the coffers of the revenue, whereas that's not happened in this case.
Perhaps it would be helpful for us to be told what you say the import is of the words "as an annual payment" within section 349.
That, as we see it, that is simply to ensure that the amount which is required to be treated as the annual payment is the gross amount, so that that's the thing that imposes the payer's obligation to deduct tax, not from a net amount, but from this notional gross amount. Section 349 is on page 826. And this one of the standard deduction of tax at source provisions under the old scheme. And so section 3491 says that where any annual payment is not payable wholly out of profits or gains brought into charge, the person by whom or through any payment thereof is made shall, on making the payment, deduct out of it a sum representing the amount of income tax thereon. So the effect of treating the gross amount of the manufactured overseas dividend as an annual payment is that the dividend manufacturer then has to treat himself, when looking at 349, as having made an annual payment equal to the gross amount.
I'm sorry, Mr. Baldwin, I got the wrong page number for section 349.
826.
Thank you.
And just to finish off with what the effect of that is, the dividend manufacturer has to deduct, or as the upper tribunals are not actually deducting out of a payment, but he's got to treat himself as having made this payment of the gross amount, and therefore treat himself as having become subject to this liability. And must account for the amount which it has had to deduct, treated as deducting, and that's back to Regulation 11 on page 877, which sets out all the rules which apply to the ORCI. And here, this is a special regime that applied to certain people who were approved UK intermediaries. And in this case, all the borrowers were such approved UK intermediaries, sort of financial institutions and banks. And paragraph 11 says at the end of the chargeable period, Regulation 11, at the end of the chargeable period, the overseas dividend manufacturer has got to pay all amounts that they are liable to, and it'll be an overseas dividend manufacturer who is an approved UK intermediary shall pay to the board the amount of any excess payable under Regulation 9(6) attributable to that period. So that's, we'll have a look at that. Those are the offsetting provisions. So there's only a payment obligation in respect of the excess. And then if there's any dispute about that, and if the revenue think that not enough tax has been deducted, then Regulation 11(4) says that the inspector can make an assessment on the overseas dividend manufacturer. So it's really only the ORCI in the present case that the revenue can assess if it considers that there's a shortfall with regards to tax under paragraph 4.2. So although paragraph 4.2 adopts the machinery of collection at source, it's doing so for a particular purpose, and it is not something which is imposing tax on the trustee's income.
If the underlying stock lending contract, pursuing my question a few moments ago, did entitle the borrower to receive the gross, this regime would still, as I understand it, cut in, and it would then provide for, it would treat the contractual entitlement to the gross as an entitlement to receive an annual payment and deduct tax from it at source.
Yes, I mean, if that's right, yes. If the Osler said, I will pay you, I owe you the gross amount, then it would.
And would you submit in that situation it wouldn't be deducting tax on the income of the lender?
No, if the lender was actually entitled to the gross amount for whatever reason, if the lender had a specific entitlement to be paid 100,
yeah,
then and absent these rules, it would have got 100. That position would be different.
So it all turns in your submission on the way in which the entitlement is constructed in the underlying lending contract.
Not necessarily how it's the entitlement is conducted, but whether the borrower, whether the lender has agreed to terms in which he gets the full contract to sum. If he gets a gross amount, if he's otherwise entitled to get the gross amount.
If he has a contractual entitlement to the gross amount, the amount that would actually be paid out on account of that entitlement within the definition of manufactured overseas dividend will still be the net, I think.
Yes.
His contractual entitlement will be rather theoretical.
Yeah, exactly. But we would say that the contracts in the present case, which are just sort of which tracked the legislation, yes, are really only explained by the fact that this legislation exists.
Certainly.
So I may take you back to Regulation 11, and you referred us to 11(1)(b), yes, where it referred to the excess payable. Yeah. And that refers to the Regulation 9 offsetting. Yes. Now, the offsets stated in Regulation 9(1)(a) will be measured by reference to all the overseas dividends which the AUKI has been dealing with. They won't be related to the circumstances of a particular recipient.
That could be the case. There are two main streams of offsetting. There's the matched, yes, matched offsetting, which covered the case if if the ORCI receives an overseas dividend and simply pays it on to the lender, then those two are matched, and the ORCI is entitled to, and obviously would, simply deduct the notional tax on the mod he receives, or the tax that has been deducted at source on the actual dividend he receives from the amount he pays. And so that in that case, where there is that matching, as the upper tribunal said, that the tax credit simply flowed through.
Yes.
Whereas the more sort of general offsetting, which Regulation 9 allows, is where there isn't that sort of matching. The dividend can't simply be traced through to the original source, and it doesn't flow through the market because, for example, the ORCI or someone who the ORCI sold the share, transferred the share to, sells the share. In that case, you can't have any matching. If the ORCI sells the share, nobody knows what happened to the actual dividend. But in that case, the ORCI is allowed under Regulation 9 to set off against his relevant withholding tax liability under paragraph 4.2 the various other amounts, and that does bring in all the other different amounts that he would have received in that particular accounting period. So that's at large, and not simply on manufactured dividends, but ORCIs are financial traders who would be receiving dividends with potential tax credits on potentially other transactions. Any surplus tax credits they had would be able to be used under the Regulation 9 general offsetting procedure. And the result of that, as we understood it, is that there was very little actual tax paid. The tax credit was in that case always offset by the ORCI. So there was no net liability under Regulation 11. It was a sort of flexible system. But it's important to keep in mind that it operated in two different ways, which the sort of upper tribunal explains as the matching. Essentially, it's like a dividend. The dividend is paid to the actual shareholder, and the onward payment is made up the chain of lending, and the credit sort of travels up that way.
But where it's non-matching, the ORCI is using tax credits which it could perhaps use for other circumstances to reduce its liability to account for the particular sum due on the gross amount.
Yeah.
Does the same sort of regime apply to annual payments under 349, where you're accounting for someone else's income?
Under 349, there's a sort of, if you receive annual payments, if there's a person who's got an obligation to deduct tax on an annual payment, and he also receives an annual payment, then I think it's right that he can deduct the annual payments, tax on annual payments received from his liability to account in that sense.
Thank you.
I'm sorry, you want to take a bit longer over this for me. If the ORCI is effectively collecting tax on somebody else's income, why would it use its own available losses or whatever to set off that tax?
Well, not necessarily losses, simply tax credits,
Yeah.
Other available tax credits it's got. Well, exactly. Why would it? But it's not under this regime. It's not setting off its tax against anybody else's liability. It's setting off its tax against its own liability.
Right. So that's your point.
Yeah.
Yeah.
But you're saying even when you're outside this regime, under Section 349, forgetting the mods regime, you're saying where a payer of an annual payment to a recipient has to account to the revenue, to HMRC, for the withholding tax, it can set off against that accounting its own tax credits for annual payments.
Yes, if it can trace, if it can say, well, I have got to pay an annual payment, but I've received an incoming annual payment. The logic is that the person paying that annual payment at the outset has deducted the tax on the annual payment, so it just flows through, and the revenue doesn't demand tax to be deducted at each stage, so that if there's a chain of annual payments, the person at the end of the chain doesn't get any income.
But is that the annual payment which is whose product is the annual payment that the payer then pays on, or is it any annual payment tax credit?
I'll check that. I believe it's any. It wasn't prescriptive. Yes. I believe it was any annual payment.
Yes.
So, I mean, you can see that the sort of material difference between the way that the match payments works, where if all that's happening is, you know, a simple transaction, the trustee lends to an ORCI, and that's the only thing that happens. The ORCI gets the dividend and pays it on. Then no one loses out. No one has to pay anything at all. The trustee simply gets the amount that they would have got anyway, and the credit flows up the chain. Now, if that doesn't happen, if the ORCI just sells the share completely, then the lender still gets the tax credit, and what the ORCI has to do is account for the tax. There's a primary liability on the ORCI to account for the tax. You essentially sort of fund the tax credit that's being given to the lender, but the ORCI is then entitled to the offset regime.
And under the contract, the Osler contract, if the borrower has to deduct tax under Schedule 23A, then he pays the lender the net amount, but he also has to supply appropriate tax vouchers. What's the significance of those?
Well, that's I don't think any significance for pension funds, but for the taxable lender, this is a standard form agreement that would apply to everybody. And for taxable lenders, they are entitled to use, possibly to claim some part of the tax that's been deducted. So I think in the present case, the evidence was that they didn't know whether any vouchers had been presented.
Well, this is the nub of what at the moment is confusing me. That at first sight you would think that if the ORCI could set its liability to account for tax against its tax credits, then at first sight it looks as though it's the person with the tax liability. But if the recipient of the net amount is receiving a tax voucher so that it can claim reimbursement of tax, then it looks as if it's its liability.
Well, of course, we're only looking at the moment at 4.2, which is part of the wider scheme. And of course, in the hands of the recipient, 4.4 comes into play.
Right.
And the amount that is treated as deducted under 4.2 is then treated by paragraph 4.4 as if it was overseas withholding tax. So,
which the lender then gets a tax credit in the ordinary case.
yes,
Yeah.
In the taxable case of the taxable
Yes.
person.
Well, in fact, the scheme gets a tax credit. There's no use to it, as I understand it.
Yeah. Well, the whole purpose of 4.4 is to enable the taxable person to sort of treat this notional tax, which has been deducted, as if it were overseas withholding tax, to put it in the same position it would have been.
Yeah.
There are, just considering your question about what would happen if the dividend, the contractual position was different to the dividend that the trustee would have gotten. There are provisions dealing with some irregular manufactured payments, and this sort of assumes that the mod is representative of the dividend.
But I thought paragraph 4.1 very carefully distinguished between entitlement and what the payment that's actually made in discharge of the requirement.
Yes, it.
In other words, it's not. The manufacturer overseas dividends is not the gross entitlement, if indeed there's a contractual entitlement to the gross.
No.
It's what the recipient gets after the deductions which the borrower is required to make under this tax regime.
Yeah, there's one sort of tweak to that, is that if the amount that's payable is not representative of the overseas dividend, then it's treated as a fee. Yes.
Yes.
Could you just help me with explaining the mechanism by which the tax vouchers, which represent tax credits, are then turned into money, if you like, or economic value in the hands of someone that does have a liability to income tax, and not a pension trustee?
Well, I think not sure that I can say all the uses, but certainly one of the uses that a taxable shareholder would use with a voucher showing sort of overseas tax that's been paid would be to go and be able to claim some overseas tax off the foreign state.
Right. So how does the tax voucher work here?
I don't think it was, in the present case, I don't think it did. In the case of a taxable person, again, I'm not sure. I can take instructions on how a voucher would have been used by a taxable shareholder.
I may be wrong. I had thought from reading the cases that if you were a taxable recipient of an amount net of the tax that had been deducted at source by the ORCI, that tax was treated as if it were withholding tax on an overseas dividend, so that if you were the recipient, you would be able to claim an exemption for the appropriate amount under whatever double taxation treaty there might be, or otherwise the default statutory provisions.
That is right, and I think what I'm being told is that the practical application of that, getting that relief, involved the presentation of a voucher to the revenue. So it was just an evidential means by which you got your corporation tax, double tax relief.
I mean, I'm being a bit slow here, but how does that work? You get your voucher.
You get your voucher.
Can you present it to the revenue and they give you money?
You make a claim for double taxation relief when you're doing your sort of self-assessment. You say, well, the way it operated was that the companies who received these dividends or deemed dividends would say, well, we've received a dividend which is a gross dividend of 100. It has had some overseas withholding tax deducted from it. I treat my UK income as 100 and I'm taxed on that, but then I have a tax credit which I can use as part of the UK system to reduce the tax. And in order to show the revenue that you've suffered this overseas tax, you give them the voucher. So it's evidence of the fact that you have really suffered overseas withholding tax.
Yeah. And the problem in reality for the pension trustee is because they're not liable to tax, they can't make use of the double taxation relief on the deemed, if you like, withholding tax.
Yes, that's simply a function, just in the same way that they couldn't make any use of the withholding tax on the dividend if they'd received it. Yeah. And that was because the very nature of a credit is that you've got to set it against your tax. And we're sort of really sort of discussing around subparagraph 4.4, but this is the provision within paragraph 4 itself, which is dealing with the position of the recipient. So 4.2 is dealing with the position of the payer, of the borrower, and imposing this obligation on the borrower, and having done that, 4.4 deals expressly with the position of the recipient. In particular, little 4a, the manufactured overseas dividend is treated in relation to the recipient as if it were an overseas dividend of an amount equal to the gross amount of the mod, but paid after the withholding therefrom on account of overseas tax of the amount deducted under subparagraph 2 above. So that puts the taxable recipient in the same position as it would have been had it received the dividend. But as we've seen, a pension fund's income was dealt with under the 1995 regulations. They were essentially taken out of the details of this regime, and under that, the sort of bespoke regime that applied to the pension funds, they were exempt from tax. So they had no taxable income against which to set any credit. So paragraphs of 4.4 didn't really do anything for them. Those were that's the basic structure of the provisions as it applied for most of the claim. There was a tax law rewrite that applied for the last year, which didn't change the provisions in any sort of substance, but it may be helpful just to show you what it looked like after, because at least structurally the provisions changed. In the income tax, so this is relevant for the 2007-2008 period, but actually a bit more significance from that in practice, because this you'll have seen that this scheme, the legislation, continued on till 2014, and it was abolished in 2014, so that actually, if there are any claims for those years, which there no doubt are sort of waiting in the wings, the new legislation would be relevant to that. So the 2007 provisions are found in page 1368. And you'll see that what this did was essentially restructure the provisions. They separated out, in particular, regulations paragraphs 4.2 and 4.4 into sort of their more natural homes. The obligation on the borrower to deduct tax from the gross mod is now found in Chapter 9 of Part 15. That is on page 1394. So Part 15 is the rules on deduction of income tax at source, dealing with various types of payments, including annual payments, but manufactured payments weren't at this stage just sort of resting on the shoulders of the annual payments. They were given their own section, and that's section 922. So that, again, section imposes the freestanding obligation to deduct, but as before, on the same notional amount as in 922 to the gross amount of the manufactured overseas dividend. So that didn't change in substance. But just in terms of machinery, it doesn't treat it as an annual payment. So again, this is obviously a collecting provision, and again, obviously, the scheme was intended to be the same here as under the former rules, but it just shows that what's going on is a collection mechanism here. The treatment of the lender under paragraph 4.4 was rewritten to part 11, beginning at page 1369. So 1369 are the charging provisions on manufactured payments and repos. The same sort of definitions of UK shares and overseas shares that applies in 566 and 567, and then it's paragraph section 573 is the sort of equivalent of paragraph 2.1. So that deals with manufactured dividends on UK shares. And does the same thing. It treats the manufactured dividend as if it were a dividend on the UK shares. So that's the equivalent of 2.1. And then the paragraph 4.4 was rewritten to section 581 of the Income Tax Act. And sort of sets out slightly different terms in substance what paragraph 4.4 was doing. if anything, that change in the structure emphasises the distinction between, you know, the 581 as the charging provision and the deduction at source being a separate mechanism.
Yes, in subsection 5 of 581, we have a similar statement to that which we see in the concluding words of paragraph 4.4.
Yes.
And could you explain its significance to me?
This is the key part of the section, which is treating the amount that has been deducted by the borrower under that regime as if it were an amount withheld on account of overseas tax. And because it's treated as an amount withheld on account of overseas tax, the company receiving the mod can say that I have now received this income that has had overseas tax deducted from it. So it then goes to the provisions dealing with double tax relief credits in the Act, and says, well, I can now, I must treat this payment as a payment from which overseas tax has been deducted. It used to be section 795 of ICTA, and that may have still been in 2007, but the basic treatment was that the recipient has to gross up the income. If there's a recipient who is entitled to a tax credit, they must treat the income as grossed up to the full amount of the 100. They enter that 100 as the income on which they're liable to pay tax on. They then work out their UK tax on that 100, say 30%, it's 30, but then they say, I have had 15 overseas tax deducted from that income, so I can deduct the 15 in computing the amount of tax I actually have to pay to the revenue. So that's what that is doing. And it's all intended to ensure that the stock lender is placed in precisely the same position that they would have been if they hadn't lent the share. I mean, the objective of this regime was to sort of free up the lending markets.
Yes.
Or at least to make it tax neutral.
Tax neutral, yes.
It says instead of as an amount on account of income tax. If it had been an amount on account of income tax that had been deducted, there would be a different regime.
Yes, you wouldn't be entitled to the general deduction of tax from your UK income. It was you needed to get into the special double tax relief credit regime. So yes. If it had simply been an amount of income tax, then if you're a company, I'm not quite sure what they would have done as a charge of income. There may have been possibilities. I'm not entirely sure. We could check that, but that wasn't this regime. The whole point was to ensure that it replicated the tax treatment of the dividend.
I'd be interested to know the 5815 and its predecessor, paragraph 4.4. What is the difference between the treating it as an amount withheld on account of overseas tax rather than an amount to account of income tax.
And it's easier to see it in the context of a trustee.
Yes.
That clearly blocks it, but we say that well, that was really dealt with by the exemption under the 1995 regulations anyway.
Thank
you. I mean, it couldn't be both. I mean, for clarity, the draftsman obviously wanted to make it clear that the effect of this treatment was to ensure that it was treated in the same way as the dividend. So it's withholding tax, and to avoid any sort of implication that, well, because the borrower was required to deduct tax under the sort of 349 procedure, maybe we've got to treat this as income tax. And no, that's the whole point, was to impose the deduction obligation on the borrower. But as far as the lender is concerned, he is treated as having paid overseas withholding tax. So that's a sort of positive case against the trustees' pleaded case. The trustees have said, well, that's just our analysis of the annual payments is just anathema to withholding tax as a matter of tax law. It is a matter of withholding tax, and of course it is by machinery a tax that's required to be deducted from this gross amount. The ordinary effect of that would be that the recipient is entitled to the payment that's been deducted by the payer. But in the ordinary case, that's because it's a deduction from the payee's income. The trustee relied on a decision of the Court of Justice in O.C. Van te Grinten and say, well, this must be a withholding tax. That was a case that concerned the meaning of withholding tax under the parent subsidiary directive. And so we'd say that, well, that can't really affect the true nature and operation of Schedule 4. But if one does look at that authority, I won't take you to it, but it's in tab 67 at electronic page 2864. It decided that insofar as tax was to be deducted from a notional construct, such as a tax credit, it wasn't a withholding tax within the meaning of the parent subsidiary directive. So it doesn't really sort of take things much further. There was one point that the trustee made below, saying one of the important differences was that the treatment of the manufactured dividend was treated the actual dividend that was paid as the manufactured dividend, whereas the mod regime was looking to this notional construct. And we say, well, that's not actually right, because under although this grossing up procedure looks at the notional construct, if one looks at the mod regulations, the 1995 relief regulations, it's the same thing. It's the mod which is exempt in the hands of the pension fund. So you say that there's no difference in treatment, and would say once one looks through the scheme, the trustee hasn't suffered income tax on its income, and so the practical effect of that is that in both the case of the manufactured dividend on the UK share and the manufactured overseas dividend in respect of the overseas share, the amount that is received by the trustee is the same as the amount that would have been received had the trustee retained the share.
And you say that the trustee hasn't suffered income tax on its income. Is that because, effectively, of paragraph 4.4, that the tax is treated not as income tax, but as a withholding tax on a sort of notional overseas dividend?
I think my real point is that under the particular regime that applied to trustees, their income was expressly treated as exempt. I think everyone else sort of fell within this ordinary regime because everyone else was needing to get the tax credits.
Okay, but would you dispute that would you equally say that the trustee doesn't suffer tax on the revenue it derives from these contracts, these lending contracts?
Yeah, I would say that. I mean, the revenue that it gets from the lending contracts or the mods. Turn to the decisions below on this. I mean, your lordships have seen that the Court of Appeal, when it came to looking at conforming construction, appeared to accept what has been described as the default position, which is basically the trustee's submission that, absent the mod regime, the trustees would have received the gross amount of the dividend, and that's the thing they needed to be remedied. And the Court of Appeal held that the conforming construction, which enabled the trustee to reclaim the amount deducted in the same way as if it had been actually deducted from an annual payment to which the trustee was entitled, restored what it called the default position. That was paragraph 87 of the Court of Appeal judgment at 298. It's worth looking at the page 298. Yes, it's although we're talking about conforming construction here, ultimately this is what the Court of Appeal fell back on when giving the conforming construction. It records at bottom of page 298 that my learned friend had pointed out it's the deduction of UK tax upon a body exempt from income tax by virtue of section 186 of the Finance Act 2004. That replaced section 592 to which I referred in relation to stock lending in relation to overseas shares giving rise to mods, which is contrary to EU law. The construction adopted by the UT simply restores the default position of section 186 that the trustee is exempt from tax on its investment income. And this default position was a concept which the trustee had sort of deployed in its submissions. At paragraph 82 on page 298, the trustee had submitted that the default position, by which it meant the position which would have obtained had it not been for the mods regime, was that the trustee would have been exempt from income tax on its investment income. But that default position assumes that the trustee's investment income was the gross amount of the mod and not the mod. And the basis for that assumption was the trustee's submission at paragraph 82 that the paragraph 4.2 was not a fiction. That's the last two sentences there, that paragraph 4.2 was said to be the provision which allocated the trustee's investment income to the particular charging regime. and the Court of Appeal accepted that, but we say that that analysis just ignores the fact that paragraph 4.2 creates the two fictions that we have identified as the annual payments fiction and the grossing up fiction. And at this stage of the judgment, the Court of Appeal contradicts its earlier findings at 38 and 39 that the trustee would not, but for the mods regime, have been entitled to the additional 15 on the hypothetical example. And we submit that the Court of Appeal was right there. The upper tribunal's analysis was essentially a variation of the trustee's case, but by reference to the contracts. The upper tribunal said that, well, you've got to look at what happened under the contracts and taking it step by step. The amount that was due was contractually reduced, and that is how they analysed the trustee as having sort of suffered the tax on its income. Whereas we say, as we've discussed, that's not the correct approach.
We don't seem really yet to have got to the nub of the issue. As I understand it, your argument, in a nutshell, is that if the trustees had hung on to the shares instead of lending them, and if a dividend, say, of 100 were declared, they would only receive 85 as a result of withholding tax. And the effect of the provisions we've been looking at is exactly the same. And so in the event that they lend the shares instead of hanging on to them, if a dividend of 100 is declared, they still only receive 85, and the deduction isn't actual withholding tax, it's domestic tax corresponding to withholding tax in a foreign jurisdiction, and so you say the legislation is tax neutral, as I understand it.
Yeah, and the reason for spending a bit of time on that was that that has been the trustees' straightforward case throughout this, and because it's that the trustee makes the case in that way because that is the way that it gets to the remedy.
Yeah.
It wants to say, well, if the trustee is right and the UK has simply charged tax on its overseas investment income, whereas it hasn't charged tax on its UK investment income, then when we look at restriction and we look at remedy, the whole case takes on a completely different complexion.
Yes, I mean, they say if you have a domestic company which declares a dividend of 100, the lender receives 100.
Yeah.
Whereas if it's a foreign company that declares a dividend of 100 on the lent shares, the lender only receives 85, and that's not the result of a foreign tax regime, that's the result of a domestic tax regime, and they say that's not permissible under EU law.
Yeah. Yeah.
So the issue really is which is the correct comparison to be making. Because that's the way it looks at the moment to me.
Perhaps to go through that, we look at the other way, the other analysis that's been adopted, which is the impairment. It has the regime meant that the trustee has effectively lost out. That needs to look at more broadly at how the regime sort of operated in practice and whether that amounted to a restriction on the free movement of capital. I mean, what the Court of Appeal, once one stands back and looks at it more broadly, then obviously the system that applied to overseas mods was different to that which applied to manufactured dividends. And there's no doubt that if you look at it broadly, there was different. But the need to replicate the treatment of the overseas share, and in particular the need to ensure that the taxable shareholder got the tax credit, meant that a different system had to be applied. For manufactured dividends, it was simple. The same treatment could be achieved simply by deeming the manufactured dividend to be a dividend, but you couldn't do that with the manufactured overseas dividend. So in order for things to stay the same, everything all had to be changed.
Yeah. Well, I think that the respondents take issue with the whole idea of keeping things the same when it's done within a single domestic system rather than done by two different jurisdictions exercising their own taxing sovereignty. And I think their position is the one is permissible and the other isn't. What I'm wondering about is, the argument in favour of your approach would seem to be these people have chosen to invest in overseas dividends, notwithstanding the exposure of those dividends to tax, unlike domestic dividends. So if you're asking for the purposes of Article 63, does the domestic tax regime create a disincentive, then I'd have thought your argument might be, well, plainly not, because they've chosen to invest in overseas dividends, notwithstanding the different tax treatment, and all the domestic tax law does is replicate that difference in treatment.
Yeah, and that's essentially what the FTT held. The FTT was the tribunal that sort of put itself in the sort of position of the trustee and said, well, how am I going to be affected by this rule? How is it going to dissuade me from investing? I'm going to get the same I would have got. I get a tax-free fee as well. So what element of this regime is going to put me off? I'm always going to get what I would have got, plus something extra, which is a fee which was tax-free as well. So that's we say the FTT was completely right on that. I mean, there isn't that much difference on liability to dissuade. I mean, there were two criticisms of the trustees made of the FTT approach, because they said, well, no, that's the wrong comparator. You can't simply look at the position of the pension fund, comparing it with its treatment under the MODS rules and its treatment of the ordinary dividends. That's the wrong comparator. You've got to be looking at the treatment between the overseas mod and the domestic provision, and that's the correct comparison to make. But we say, standing back from that, because they were both treated in the same way, that comparison doesn't produce anything that's liable to dissuade the trustee. So one stands back and asks in the real world, what was it in this regime that was liable to discourage trustees, since they were guaranteed to get the return that they would have got? And one's looking back, everyone agrees that the relevant movement of capital here is the investment by the trustees in foreign shares. So one sort of steps back and says, well, they were prepared to invest in these foreign shares, knowing that they would be suffering the 15, but that didn't put them off. And absolutely clear as a matter of EU law that there is no obligation on the United Kingdom to relieve that taxation as a matter of the juridical double taxation that suffered. If one looks at the baseline position of the fact that the dividend from Italy would have been received as 85 by the trustee, whereas the dividend from the UK company would be 100. You know, that, the FTT said, might discourage the trustee from investing in overseas shares. You know, the difference between the 100 and the 85 is possibly something that would dissuade a trustee, but there's no problem with that. That is just a product of Italian withholding tax. And the cases, Haribo and a list of others, say there's no obligation for the UK to provide any form of relief for that. And so one's got to look at what's the cause of any potential, you know, dissuasive element in all this, and it always comes back to that.
Well, but the argument against you is that whereas juridical double taxation arising as a consequence of a lack of harmonisation of tax regimes within Europe, and with the consequence that France may, or Italy may impose a withholding tax on dividends, whereas the UK doesn't, that's a permissible state of affairs, even though it inevitably creates an economic incentive, other things being equal, for people in Britain to invest in British shares rather than Italian shares. But it's said against you that it ceases to be permissible, but whereas that is permissible, it's completely impermissible for the UK taxing authorities to establish a regime which treats domestic dividends more favourably than overseas dividends.
And what the respondent is seeking to do is saying, well, look, we are trying to say that what is that the effect of the mod regime is a form itself of parallel, the exercise of parallel taxing rights, and we can't do that. But we're not saying that. We're just saying that the starting point of all this is the fact that the trustee would have got 85, and we haven't changed that in any way by the regime.
Yes.
So we're not.
Well, I don't want to repeat myself, but the argument against you is it's all well and good if he only gets 85, because that's the result of the Italian government's decision to impose a withholding tax.
Yes.
It's different if it's the result of the British government deciding to tax foreign dividends less favourably than British dividends.
And we say that it's not the reason why they get the 85 is not the result of the British system. The reason that they get the 85 is because the 85 is the dividend, represents the dividend of which the manufactured overseas dividend is representative. The distinction that was made that the revenue can't, the UK can't come along and create the shortfall is one that I have to accept, but it's not. We've seen how the mod regime operated, and it doesn't create the shortfall of the trustee's income. That's not the problem. And if there is any problem, it comes back to saying, well, still, in order for there to be a restriction, one still has got one can't just seek to find some ephemeral difference in treatment. You've got to see, is there something which is going to dissuade the pension fund from investing in overseas shares? And that's a real world question. And
since we're debating juridical double taxation, can you tell us what you say about paragraph 42 of the Court of Appeal's judgment, where they seem to feel that this is page 284?
Yes, well, I think this was the way that the trustee had presented to the Court of Appeal, that Revenue's argument relied on the concept of juridical double taxation as a means of preserving or entitling the revenue to apply a tax deduction on the mods. So the UK government had deducted tax from the mods, and then they were coming along and saying that is just a form of juridical double taxation because it's representing what would have happened in the foreign state, and the Court of Appeal said no, it's not. It's not. That's not juridical double taxation. That's just the UK exercising its own authority to require tax to be deducted. But all that assumes that the effect of the UK provision was that the UK was imposing a tier of juridical double taxation on the trustee's income, which it wasn't.
I rather understood the Court of Appeal to be saying that even if it would be legitimate for a domestic scheme exactly to mirror what would happen if the shares were retained, so that you did get juridical taxation, it couldn't be said of this scheme that it did exactly mirror that.
But
and that does seem to be addressing your argument. Well,
yeah.
Thus far as I've understood your argument in relation to juridical double taxation, you're saying, well, if the overseas share was retained by the trustee, it would have suffered the 15 loss of Italian tax. That's juridical double taxation. And the domestic scheme simply replicates that and therefore cannot be said to have any additional dissuasive effect as regards foreign investment. Have I understood
that's one part, but also the second part of the argument is that the treatment that was adopted for the overseas shares was the same as the treatment that was adopted for the UK shares, in the sense that both were taxing seeking to tax the recipient of the share in the same way as if they had received the actual share. So ordinarily one's starting from a position of, well, how is the UK system taxing the overseas dividend less favourably than the UK dividend? And here the object of the regime for both manufactured dividends and manufactured overseas dividends was to put them in the same position.
Right, but have I misunderstood what the Court of Appeal is saying in paragraph 42? They seem to be, as I understand it at the moment, addressing the first part of your argument, that there's an exact replication in the domestic mod scheme of what would happen if the share was actually retained, and the Court of Appeal is saying not so, there isn't an exact replication.
I think my understanding was slightly different, but you may want to answer. Lord
I'm looking for assistance.
Yeah. I mean, the Court of Appeal refer to the regulations that prescribe the amount of the tax to be deducted, and they say that doesn't correspond to what the withholding tax might actually be in the country concerned.
Yes, I think this is part of the when one gets to the conclusion at 42 through what the Court of Appeal was saying in 41, and they were saying that in the middle of that paragraph, they were saying that the borrower will not have retained the share, and the dividend of which the mod was representative may not then have been subject to overseas withholding tax.
And a classic example is this, isn't it? If the borrower from our lender, the Yorkie, either sold or on-lent those shares onto an Italian borrower, then there'd be no withholding tax levied on a payment of the dividend by the Italian company to its by then Italian shareholder. Yeah. So at the bottom of the goodies tree that generates the cash flow, there isn't any withholding tax going on. Isn't that what they're referring to in this paragraph?
That's where they started. They start at 41 and they lead to 42. And I think it's this where they see the difference arising was from the fact that and what they say is the dividend of which the mod was representative may not have been subject to overseas withholding tax. And again, as we would say, the dividend of which the mod was representative, we would say, is the dividend that was paid to the UK. So, looking at seeing a difference between that arises out of a hypothetical dividend that's paid to somewhere completely different is taking it outside the scope of the regime completely. And I say it's completely irrelevant.
Well, the model on which the tax with which we are here concerned is based, as I understand it, is what would have been the withholding tax if the relevant foreign company had actually paid the dividend to the lender.
Yes.
But the real world is, I think the Court of Appeal is saying, actually rather more complicated.
Yeah, and that's so in particular gets complicated if the share is sold. We're being asked to consider it, and this goes in two ways. It's partly to do with what's the scope of Article 63 here, where everyone agrees that the relevant movement of capital is the acquisition by the pension fund of the overseas shares, and everyone agrees that under the case law that that doesn't involve simply looking at the acquisition of the share. It involves other transactions such as dividends paid on the share, which are effectively indissociable with the acquisition of the share, or necessarily presupposes the acquisition of the share. And because of that, we've said, well, yes, getting a stock loan, a manufactured dividend is potentially within the scope of Article 63. So, and here, you look at the transaction by which the stock loan was effected. It was a transfer of title from the pension fund to an Orkie, and under that transaction, nothing really changed. If the Orkie gets the dividend, then the dividend is paid on completely neutrally under the matching provisions, and the trustee gets exactly what it would have got. If the Orkie then goes and sells the share off into the market, and nobody knows what happens to the share, and somebody in France eventually gets a dividend which is bigger than the dividend that the trustee would have got, and say, well, I mean, that is sort of not indissociable with the trustee's acquisition of the share. Something different has happened at that stage. That isn't part of the trustee's sort of investment ownership of the share. It's not part of the trustee's. It's not in any related to the trustees' investment decisions. It's a part of the trading decisions of the ORCI to sell on the shares, cause that share to move. So the actual dividend is really irrelevant to this exercise. It's outside the scope of Article 63 as such, or it's just too remote. There is a concept of remoteness that we've referred to in the case law as to where you draw the line. So if one looks at the actual transaction, that sort of differential wouldn't arise. You've got to assume a further transaction of the ORCI going off and selling the share or indulging in some other agreement by which it gets the benefit of a lower withholding tax rate. But that's nothing to do with the trustees of investment activities.
But I mean, it is reflective of the real world, isn't it, in stock lending, that ORCIs will use stock to lend themselves.
Yeah, I think the evidence was that one of the ORCIs' motives in borrowing was the share was to do all these things, including dividend arbitrage. But that's the ORCIs' motives and its transactions and its trading activities.
But what I'm struggling to understand is whether you criticise as wrong the assessment by the Court of Appeal in 41 and 42 that says that although you're right that what the ORCI does with the borrowed share is in a sense the ORCI's own business, the fact that there is a mismatch between what is paid through to the lender, subject to what is really a notional withholding tax at a particular rate, and the commercial realities in terms of the returns that might otherwise be generated from overseas investments, is the prism through which one should assess whether there is a restriction on free movement of capital under Article 63.
Yeah, and I think what I'd say is that the mismatch which the Court of Appeals has identified is just an irrelevant mismatch.
Well, because it's too remote.
Well, because it's concerning this dividend, which A is too remote and B is reflective of a sort of state of affairs which just can't arise for UK shares. And we're just trying to compare, the tax treatment of a UK share, where you just simply get the share, and the tax treatment of the overseas share. And what the UK system does is treat you getting the same share. You're treated for tax purposes as getting as if you got the share that you would have got. Now, the fact that an ORCI can do various other things with a manufactured overseas dividend in its own trade is not something that can be compared with a UK share and a UK manufactured dividend, because there's just that sort of differential couldn't arise. So you're not comparing sort of two objectively comparable situations in arriving at your perceived difference in treatment. You're just saying that, well, here is a one type of investment, whether you can do one type of thing, and here is another type of investment which you can do a completely separate type of things, and well, somebody else can. There's a difference there. That must be a breach of EU law. And we say, well, that's not correct. You've got to the building blocks are, so you've got to find a difference in treatment which relates to situations which are objectively comparable, and then you've got to ask of that, is the trustee liable to be dissuaded by that? So the levels are, is this within the scope of Article 63 at all? If it is this sort of thing too remote? If that is within the scope and you can look at it, then you have to ask, well, is that objectively comparable to the situation which you're being asked to compare it with, which is the situation with the UK share? And it's like a completely different world that is opened up with the lending of overseas shares. If you look more narrowly at what the transaction that the trustee did vis-a-vis the ORCI, he just moved shares to a UK lender, and the tax consequences of that were exactly the same. The dividend just flowed through. You need to assume that you can look at the third party's activities in seeing whether the legislation is on its face sort of restrictive. And ordinarily, in order to find out if there's a restriction, you're just looking at the legislation. I mean, the cases that we've referred to on liability to dissuade are all Fakuyan and Mannanen. They're looking at cases dividends that have come in from overseas shares, and they've been one way or another subjected to a less favourable tax treatment than dividends on UK shares, so that the net return that the investor is getting as a result of the domestic regime is less than the return that they're getting with their domestic shares. Now, that just is read from the legislation. The difference in treatment between the overseas shares and the UK shares simply is apparent from the legislation, whereas here, in order to get anywhere near to the impairment theory, you've got to be taking into account all the steps and decisions taken by third parties, and seeing, well, can the trustee somehow have shared in those? That's not looking at an objectively comparable situation. I mean,
this may be a little bit of a hair, but what you're saying rings certain bells with me in the difference between the two Court of Justice decisions in FII, where the first decision was looking at, I think, deduction of notional foreign withholding tax. And then that was revisited. I mean, this is me doing it from memory, and I may have mischaracterized it. The second one revised that to look at actual withholding.
It's the other way around.
Oh.
The initial judgment allowed deductions for tax actually paid, and then it was worked out that because the tax that people actually pay depends on the losses they've made, the reliefs they have available, and in fact, a lot of companies don't pay very much tax at all because of these factors. To do a proper comparison, you should be looking at the nominal rate of tax.
Yes, sorry, I have misremembered. Yeah. All right, let me think about that some more.
Yeah. I mean, one of the cases that has been relied on below, that's sort of allied to the FII case, and is the bridge between FII and the present case, is the BTPS scheme, which looked at the position of an exempt pension fund not being paid a credit in respect of overseas shares, whereas it was paid a credit in respect of UK shares, and that seems to have formed part of the background as to why there was a restriction in the present case. But that does illustrate the sort of differences in treatment that can found a restriction. It may be useful to have a quick look at that case, and it's really looking at what really can constitute a dissuasive effect.
Yes, I'd welcome that, and I'd welcome a statement as to why you distinguish the current circumstances from the BTPS case.
Yeah.
Thank you, but we'll look at it first.
So, in the authorities volume at page 1300, and it helps to show the court's approach both on restriction and on liability to dissuade. It concerned the compatibility of a particular regime, which your lordships may have considered in the context of the FII decision, the foreign income dividend scheme. And the foreign income dividend scheme was a particular aspect of the UK's regime for dealing with economic double taxation of corporate profits, which had been looked at by the court in the 2006 FII decision. And the court summarises the domestic regime on page 1305 and 1306, looking at the foreign income regime.
This is the Advocate General, is it?
Yes. So this is the Advocate General. He sort of usefully summarises the regime, and you may recall that under the general UK regime, a company paying a dividend was required to account to the revenue for ACT, and the dividend would carry a tax credit for the shareholder under section 231. This is dealing with economic double taxation, and the shareholder was entitled to use the tax credit to set off against their taxable income, and a person without a tax liability, such as a pension fund, could claim a payment of the tax credit under section 231(3). And one of the issues with that general regime, which was considered in FII, was that ACT represented an enduring cost for companies, multinational companies that had lots of overseas dividends, because they didn't have enough profits against which they could set off their ACT. And the FID, the foreign income dividend regime, was introduced to alleviate that problem, and it operated with two features: the company paying a foreign income dividend, which was a dividend that could be matched with sort of overseas profits in its subsidiaries. The company paying that dividend could declare it to be a foreign income dividend, and if so, it was required to account for ACT, but it could reclaim the ACT back from the revenue. So that dealt with the surplus ACT problem. These multinationals were entitled to pay their dividends without accounting for ACT. But the quid pro quo for that was that the recipient of the FID was not entitled to the tax credit. And as your lordships will remember, in the main Court of Justice decision in FII, the Court of Justice held that the FID regime was incompatible and the main conclusion was that, well, the ACT system was incompatible, and they held that although the FID regime may have ameliorated that, lessened the problem of surplus ACT, nevertheless, companies still had to pay ACT, that was one problem. And also, the foreign income dividends were treated less favourably than the domestic dividends in the hands of the shareholder, because the shareholder was not entitled to receive a tax credit under Section 231. Following that decision, the pension schemes brought a claim saying that their rights had been infringed because there was a difference in treatment as between the receipt of a foreign income dividend and the treatment of a UK dividend. Because in the case of a UK dividend, the United Kingdom allowed them to claim 25 on a dividend of 100 by way of a tax credit, so that the UK would write a cheque to the pension fund for that amount. But in respect of a foreign income dividend paid by a UK company, the UK revenue did not write them a cheque, so the pension funds did not receive the same payment as they did in respect of ordinary domestic dividends. Now, the BT pension scheme challenged that regime, and the Court of Appeal referred questions to the Court of Justice, saying, well, one of the arguments that the Revenue were using in that case was, as it was a foreign income dividend, was simply a dividend paid by a UK parent company to a UK pension scheme, then that was a wholly internal situation, and Article 63 shouldn't have anything to say about it. The UK weren't saying there wasn't a difference in treatment. They were saying, well, this is just an internal matter, and the court rejected that argument. The court sort of summarised the effect of the FII decision at paragraph 34 of its judgment at page 1325. At paragraph 34, the court said that the court has held in particular to the extent that the UK tax system, including the FID regime, deprives shareholders receiving dividends of their right to a tax credit where those dividends originated in the foreign source profits of a resident company, contrary to what was provided for in the case of dividends which may have their origins in the national source profits of a resident company. And then 36, such an absence of a tax credit for shareholders not subject to income tax in respect of dividends, such as the trustees, has the effect of discouraging those shareholders from investing in the capital of companies resident in the UK, which receive dividends from companies resident outside the UK. So that was a difference in treatment that was applied to pension schemes as between dividends from domestic companies and FIDs. That was unfavourable tax treatment under paragraph 42 that was due to the fact that the dividends had their origin in the profits that the company received from a non-UK resident company. So there was, the shareholder investor who was a pension scheme was subject to a, on the face of it, manifestly less favourable treatment of foreign-sourced dividends under the legislation. And it was that that difference in treatment had the effect of discouraging the shareholders. So that was the liability to dissuade. So why this case is different to the present case is that under the regime for economic tax credits, the UK would make a payment to the pension fund in respect of a dividend received from a UK company. So if one's looking at the receipts of the pension fund, if the pension fund received a dividend of 75 from the UK company in respect of an ordinary dividend, it would be paid 25 by the revenue, whereas if the pension scheme received a dividend from the same company, but that was a foreign income dividend sourced out of foreign profits, then the pension scheme would not receive that payment. So in the one case, the UK revenue was sort of topping up the dividend, in the other case it wasn't. Whereas here, the UK is not making any form of payment in the case of a UK dividend or a UK mod. The company receiving the 100 from the UK dividend is simply receiving 100 of profits, and the company which receives the mod, which represents those 100 of profits, is receiving the same amount. Whereas here, the reason why the company only receives the dividend of 85 and only receives a final amount of 85 is not because the revenue have decided not to pay them the extra 15, it's because that extra 15 was taken off at source from the actual dividend, and therefore the compensation payment, which represents that actual dividend, was also only 85. That was all I was proposing to say on the BTPS scheme at this stage. It does sort of reappear in terms of restriction. That may be a convenient moment to...
Well, if that's a convenient moment for you, then certainly. I would observe we don't seem to have finished the discussion of restrictions yet, and we still have to come to justification, what you want to say about standstill, and the issue I highlighted at the outset of remedies. So we'll have to make, I think, more rapid progress this afternoon.
Yeah, what we've done is certainly the most sort of dense part of the analysis, and with much of the others, I'll be able to rely on our written case.
Very well. 2 o'clock.